Hi, my name is Rita Anrichinda. I welcome you to IP series where we talk about recent IP cases and development globally from copyright, trademark, patent, industrial design, plant varieties, and geographical indication. If this is your first time joining us, please subscribe and favorite my podcast so you don't miss any episode. And if you've been listening prior to today, thank you for always listening. Today's episode is going to take a different turn. We have a guest. I'm going to let him introduce himself, and I hope you guys get to enjoy what we talk about at the end of the day.
Hi, my name is Mark Jaffe. I'm the partner at Tormark Law based in Berkeley, California. I practice law but back and forth between New York and California with my partner, Tor Eklund. I focus on creative individuals and creative companies in virtually all their aspects, from when they start their company to all their contracts, and in particular, copyrights and trademarks, and making sure that artists get to protect their work. I've been doing this for about 13 years, mostly in New York. Recently moved out to California. And I've worked with many artists in protecting their rights, but also getting their rights back from companies to who they assign them, so they have more control over their work and make their money. And I'm really happy to be here, Rita.
Thank you so much, Mark. I mean, your profile, your bio is really impressive, and I know I did come across one of your tweets, and that's how I started following you. I like the way you tackle or address certain IP issues within your jurisdiction. So, um, first of all, you are our first guest. This is the first time I'm having someone with me on my podcast. So, thank you once again
That
for
is
agreeing to do this.
that is flattering, and I really appreciate the perspective that you give
Thank
on
you
your
so
on
much
on
as
your
well.
show. I have a Rita, of course, is we discovered each other through Twitter. I'm Mark J. Kings, and that's how I've met and have a number of people like yourself that I've gotten to talk with later. I have found I have a good following of lawyers in Nigeria and also South Africa, and I think it's terrific. I love to have the perspective and the outreach.
So, back to today's topic. So, the Nicki Minaj and the Tracy Chapman case. Could you just give us like your perspective about it? Because I had issues when I first saw the post
Yes.
where Tracy Chapman sued Nicki Minaj for sampling a song, and the song wasn't released, but somehow it got into the public domain. Like, what are your thoughts with regards to everything that happened in that case?
Okay. So I start with how it began.
Yeah.
I'll give a brief I'll give a brief overview. So Nicki Minaj went into the studio to record new music for what will become the album that was released, the Queen album. And in this case, she was recording the album with Nas, and they used and experimented with a Tracy Chapman record. This song, Baby I Can Hold You. Her song was called Sorry. It was never released. I never heard the Tracy Chapman song. I mean, the Nicki Minaj song, but if you listen to the Tracy Chapman song, you can see why she'd want to use it for a song called Sorry. And they recorded that in the studio. What she said was, and I don't think this is disputed, was that she did it in the studio because she didn't know if she can get a license, and she wanted to send it to the copyright holder later to get that license, because artists who are sampled often want to hear the actual thing before they give their approval. Nikki didn't actually know that it was Tracy Chapman. She thought it was somebody else, but it doesn't really matter because she did find out. She recorded the song. She had her people send it to Tracy Chapman. Tracy Chapman said no. In fact, she's well known within the industry for saying no. She doesn't like her songs being sampled. There's an unofficial do not sample list. So she said no. She said no multiple times. And Nikki tried to reach her on Twitter and say, hey, I know you, if you listen to this, you really like it. And she got no. That's part one. Part two. She sends messages to DJ Funkmaster Flex. I don't know if he's internationally known, but out here he's probably one of the longest and most well-known hip hop and R&B radio DJs ever. And tells him about the song and says, "I want to send you this song. I think it's great. You can get an exclusive." I'm paraphrasing. "It'll be only yours. It's not even going to be on the album." Later, Flex plays it. He announces that he's going to play it. He announces that he's the only one who has it because it's not on the album. And then he plays it, I think, just once. There's actually a missing link in the evidence, whether or not Nikki actually sent it to Flex. She might have.
I know
Yes. Yes.
Reports saying it was Nikki's team that actually sent it to the DJ to play it on. But the issue now is, wouldn't the team be liable for whatever happened afterwards?
It's possible, yeah. It's possible. That's what's going to go to trial. And some of the most interesting things that came out of this case is what's not going to trial, because a judge ruled in favor of Nicki Minaj.
Yeah.
So there are really two aspects to the lawsuit. One was Tracy Chapman sued over creating the song in the studio. And the second was over her sending it to Funkmaster Flex, and Funkmaster Flex played it. After all the evidence was taken and the testimony was taken, the parties moved what's called summary judgment. They wanted a judge to rule on their favor so that it doesn't go to a jury. And Nicki Minaj argued that her recording in the studio was fair use. Now, fair use is part of U.S. copyright law, excuses uses of other people's copyrighted works when it's determined that these are the kind of uses that you don't want to discourage, because copyright is supposed to foster creativity. So we don't want to discourage creative uses, and particularly uses that transform an original work and make them something different. So in certain cases, we can find that fair use and you're excused from copyright infringement. Now, I don't know, you tell me, is there an equivalent to fair use in Nigeria?
Yeah, what we have here in Nigeria is called the fair dealing, and then it's been segmented. So you have the one for sound recording, you have the one for broadcast, and you have the fair dealing principle that applies to literary work. So I think it's similar because you have issues, elements like private use, caricature, pastiture, and the rest of it. So it's a bit similar, but I think it's how it's applied. And then you have instances where people barely go to court to, challenge infringement or any dispute whatsoever. So we have little or no precedent to lean back on when it comes to the fair dealing principle.
Right. Great. So in the U.S. copyright law, it's called fair use. There are a number of factors that courts apply. Interestingly enough, there are not a lot of fair use opinions about sampling, but there are many about music. And the most well-known one here was the group 2 Live Crew, who got all the way to the Supreme Court because they made a different version of the song Pretty Woman, which was originally recorded by Roy Orbison, and the publishers sued. 2 Live Crew was huge in the U.S. about 30 years ago. They were best known for making basically borderline pornographic songs. And this one was a relatively tame for them, but they took the Roy Orbison song, which was an innocent song about a pretty girl, and made more raunchy lyrics. And they said this is fair use because we were making fun of the original song, which was innocent, and we made it raunchy. We changed it. We transformed it. And what the Supreme Court held was when you're using another work to comment on the work, for instance, making a parody, you have to be able to evoke that original song. You have to be able to use parts of it. And that factors into fair use. And from that Supreme Court decision, we know a lot of how we apply fair use to artists when they use other people's music. The main point that Nikki was arguing was that artists should be allowed to experiment with other people's music in the studio. That when she was recording in the studio, she wasn't planning on releasing anything until she got a license. But before that point, artists should be able to get into the studio, use other people's work, sample what they want, create different versions, and essentially experiment. And also, that when copyright holders are contemplating whether or not they're going to approve, they want to actually hear the finished product. They want to actually hear a demo. And in fact, they said, and this wasn't disputed, Tracy Chapman had previously asked for demos before when people have wanted to license her work. Tracy Chapman didn't agree. She said what you were doing was a commercial use because you wanted to release it on the album and you wanted to play. So ultimately the court agreed with Nicki Minaj. The court agreed that use of that recording, and really more specifically the composition that Tracy Chapman was suing on, was fair use. Because artists need that flexibility. Artists need to be that creative in the studio. And the court also agreed it's not a commercial use because creating that song in the studio was not commercial. There would be no sale, there would be no license, and there would be no release until she got approval. And the public benefits, the court said, from that kind of use. It serves a public interest to let artists experiment by using other people's works before they release them.
So why do you think artists prefer to sample songs instead of licensing them? I mean, you already have an idea that you're going to use a certain artist song or sample it. Why don't you just go ahead to license it instead of playing around with different beats and then coming up with one at the end of the day and going through all the stress of getting IP clearance and getting the no, just like Tracy Chapman, who has always said no. So if you know this person will always tell you no, why not just license it at the end of the day instead of sampling it?
Why would they use this song?
Yeah, why would they sample instead of licensing the song?
Well, sampling would require a license, but typically a sample in the US would require at least two separate licenses. One is for the composition, right? For the songwriter or the publisher. And in this case, that was Tracy Chapman. And the other is for the recording itself, because you're using a sample. And that typically belongs to the record company because the artist, who also was Tracy Chapman, typically assigns it to the record company. So this lawsuit wasn't about the recording. Tracy Chapman didn't own those rights because most likely she assigned it to the record company. It's in almost every recording contract. But she did own the rights to her songwriting. So there's been a standard, an industry standard for artists over the last 30 years to get licenses before you sample, before you release them. But it's also been common within the industry to create the songs first. To actually play around, use other people's works, and before you release them, send them to the copyright holders and ask for their approval so they can say whether or not they want to do it.
So if we're going to take a different twist to this case now, would you say Nicki has the right to sue the DJ for releasing the song to the public without her permission?
That's a great question. And that's how we get to the second part, because this lawsuit's not over. There's still a claim that Nicki sent it to Funkmaster Flex, and Funkmaster Flex played it on the show. And unless these parties settle, that's going to go to trial. And Chapman is going to seek, Chapman's going to seek monetary damages for that. And Nicki's going to argue what a jury will determine, that I didn't send it to Flex. And Chapman is likely going to ask for a jury instruction and get it that says the jury can infer based on these facts that she did, because she told Flex that she was going to do it, and not long after that, Flex played the song. So let's say, I think your question is, if, let's say, Nicki Minaj loses,
Yeah.
can she then seek a
Eventually.
recovery from Flex? Can she then? Yeah, I think so. I think that's a possibility. It would really depend upon the facts. If other people access that work, the Nicki Minaj song "Sorry," and Nicki didn't send
Yes.
it to him, and in Nicki's theory, Flex should have known that he shouldn't have played it. That he should have just listened to it on his own and say whether he likes it. Then she might try to get that recovery from Flex. I can't tell you that would be a strong lawsuit, but if Chapman gets a big enough monetary recovery from the lawsuit, then Nicki might want to do that.
So, what is the music industry like? I mean, coming from the judgment that um Nikki won, what's the atmosphere like? What are people doing? What are the stakeholders saying? What is everyone's reaction? Do you think it's a good thing? Was the judgment a good one or a bad one at the end of the day?
I think most people in the industry would agree it's a good one, not because it was surprising or
Yeah.
groundbreaking, but because if it ruled otherwise, if it ruled the opposite, it would have been problematic. Because in theory, then any artist in a studio could open themselves up to liability just by using other people's work. And often it's going to be harder to get that approval before they even have the work before they even record. So what this did was affirm what had already been common within the industry. And you and I have talked before about uh, copyright law on Twitter and such. And one of my themes is that copyright law is often a reflection of what society expects and consumer expectations and industry standards. A more plain way to say it is, if we've all been doing it this way and we've become used in a company to do it this way, then that's a good factor in saying that copyright law permits it. So I do think this was
And
a
we
good
know that.
thing. And I think most within the industry, not everybody, would.
Yeah.
Others would find it problematic because they think Nicki Minaj and her people were disingenuous in recording it
I think so
because it
too.
would.
I think so too. I said I think so too. Because I think the whole thing was just really fishy. Nikki asking and then the team going ahead to do it. Tracy Chapman refusing, but he still went against her decision to do what you wanted to do. So I think everything was like a strategy, and it was planned, and then the whole thing just took off from there.
Going to be a difficulty and a challenge for her if this goes to trial. Sending it to Funkmaster Flex is not the same thing as sending it to any other producer and and any of your friends. You're sending it to somebody who is one of the longest running and most well known shows in radio over the last, I don't know, as long as I can remember.
So I have another question, but deviating from the Nikki and the Chapman case.
Sure.
How does DMCA work in the US? Like, if someone issues a takedown notice, how does that really work? How do you implement that?
The
Like
DMCA?
in Nigeria, yeah, so we have issues where an artist releases a song in Nigeria, and then before other 24 hours, you have several websites that has the song on their site, and then you're having issues on sending down takedown notices, and then you're having enforcement issues, and everything is just piling on. So with time, everyone has gotten used to, okay, last, let everyone just hear my song. So you have illegal downloading and all of those things. How did you guys go about it there in the US?
Well, the artists who don't want their works online without their authorization have to unfortunately spend a lot of time trying to get it off. In the US, we have the DMC safe harbor, which will make YouTube and Twitter and Facebook and any other host not liable for copyright infringement for things that other people upload to it. But there are certain things that they have to do to get that safe harbor and to not be liable. And one of them is they have to have a mechanism where copyright holders can let them know my stuff is on here. I didn't approve it. You have to take it down. And then they have to take it down. Google apparently gets millions and millions of these per year. It also owns YouTube, so it gets millions, and it really doesn't have the resources to investigate each and every one, so it's typically going to take them down. From the perspective of copyright holders who want to take things down, many of them don't like having to do this because it takes too much of their time, and it's metaphorical whack-a-mole. They get something taken down, they find something else, they get something taken down. And it's just a lot of their work. From the perspective of YouTube and Google, I think many of them are satisfied with how it works because it gets them out of being sued. And other people think that the safe harbor results in too many takedowns of materials that should be allowable. In fact, many of them could be fair use, but the hosts, Twitter and YouTube and the rest of them, can't review every single one of them. So the balance of that is when something is taken down, the host provider, YouTube, has to notify the party that uploaded it. And the party that uploaded can challenge it and say, this isn't infringing, I didn't use your work, or this work is fair use.
So, in wrapping up now, what would you say is the thin line in fair dealing and between fair dealing and infringement?
Right now, this is really difficult, and this is one of the hardest things for artists who want to use other people's work, is that there just aren't a lot of bright lines. Can you hear my dog whining? There aren't a lot of bright lines. We have case law. I talked to you about the Nicki Minaj one and the famous Two Live Crew one, and there are a few others related to music. There are very few over the whole 30 plus years of sampling related to whether or not sampling is fair use. There's a recent one involving Drake's use of a sample, but it's pretty limited. So for artists who want to sample, and especially if they want to do it on a mainstream scale, like a Nicki Minaj album, they typically don't take risks and use other works without getting licenses. There are more independent and underground artists that take those risks because, in part, they don't think they're going to be noticed. And there's more arising out of mixtape culture. There have been the mashups. For some reason, copyright holders don't tend to go after the mashups. Some people have told me they think there's a better argument for mashups being fair use than samples. I don't really understand why, but I do know that some of the biggest mashup artists don't get pursued. The reality is fair use is a good thing. We rely heavily on it in the US, but no one particular artist has clear guidance over what they're doing is fair use. And not every artist can consult with a lawyer every single time they're using somebody else's work. And it makes sampling very risky if you're not getting both licenses.
Okay, then final
Sure.
question. So now, amongst all of these persons, so the broadcaster, the broadcasting station, the DJ, and Nicki Minaj team, who do you think is more liable if we decide to call their act an infringement? Who is going to be more liable in the act?
In the Nicki Minaj lawsuit?
Yes.
Well, Nicki Minaj, I think, was the only one named. So she didn't sue Nas, as far as I know. She didn't sue Flex. She can, but I don't think she did, and I'm not really sure why. What she did was sue what's called John Doe's, which is typically who you sue when you know somebody's done something, but you don't know who they are, and you think you'll later find out. But that's not going to help her here because it's really when you know there's a specific someone. I wouldn't be surprised to see this settle because from Nikki's perspective, she has a good possibility of not winning on the merits, on the facts. But from both parties' perspective, we don't know what the damages will be. It's a big risk for Nikki, and for Tracy Chapman's perspective, I think it's very possible that she could win, but not get a lot of money out of it. The song was not released. It would have been different if the song was on the Queen album and sold 1 million and 2 million copies. But I just wouldn't be surprised if there's not a lot of money in the recovery.
Thank you so much, Mark. It's really been an interesting time with you. Thank you for sharing your thoughts.
Sure.
Yeah, I hope you had a good time as well,
I
because I did.
I did. What do you think? How do you think this would play out in Nigeria?
So we've had a couple of issues. So there was this sampling issue between Tiwa and another artist, and there was a takedown notice, and eventually they settled, and the song came back up on YouTube. I think the awareness is growing by the day. Artists are becoming more aware of the rights they have and what they need to do. I just think that we need to do a lot of advocacy in terms of letting artists know the right things to do when it comes to sampling and what is fair use, what is considered to be an infringement, and everything that has to do with that. But I think we're doing good so far. But I'm looking forward to see how the whole case plays out at the end of the day.
Sure. Did you say Tiwa? Is
Then
it Savage? Is that?
yeah, Tiwa Savage.
Mhm.
So she was being accused of sampling a particular lyric, and the song was taken down. She had a couple of million views, and after they settled, the video was back up online. Then we had instances, another one last year with Jogodo, but that didn't go to court. The party settled out of court. So just few cases that people, just take notice of, and then they just rush to settle. But then I think so far the entertainment industry is doing well. Just need good structure. That's all.
Right.
So yeah.
Yeah, we can do a whole other show just talking about sampling and fair use and something called de minimis.
I mean, I have an idea, but when you're talking about the practicality of the mean, like, what does it entail? So let's still talk about the Nicki Minaj case now. How would that play out?
Oh, I doubt. If I don't, I haven't heard the Nicki song because it didn't get released. But
Yeah.
I strongly suspect that de minimis would have been a loser, and there's no way they would have tried it. De minimis is really only going to work when you use no more than 1 or 2 seconds, and you really don't use the heart of the work. Now, again, I don't know the Nicki song, but I listened to the Tracy Chapman song and the part where she says she's sorry, and I think it's likely she used a good part of the song. In fact, I think that's already in the facts. De minimis. I advised one client on a de minimis defense, and they wound up prevailing in court. But it's not something that's going to work if you've used more than a couple of seconds. There's no bright line rule, but if it's easily identifiable,
Yeah.
then it's likely not going to work.
I was actually going to review the Nicki Minaj and Tracy Chapman case myself, like I always do. Why I had a second thought, and I said to myself, why don't you just reach out to an expert, especially someone in the US that would be able to shed more light on what the case was about? Because I know on several platforms I've seen discussions going on whether Nicki Minaj sampling was fair use or not, and whether it was a copyright infringement. So yeah, thank you so much.
Great. This has been great. I really enjoyed this, and I'm very flattered that you had me talk on this. And if I'm the first person you had talk on this, or the first, from the US, I'm just
Thank
extremely flattered.
you, thank you. And you're doing a great job too on Twitter. So yeah, we'll come to an end today. Thank you. Hopefully you join us some other time.
Right. Right. And if anybody wants to reach out to me, Twitter, it's Mark J. Kings. The firm is Mark at Tormark Law. And of course, you can reach out to Rita as well, who does really informative and terrific threads and podcasts on a regular
Thank
basis.
you, Mark. Thank you so much. Thank you. Like Mark said, you can reach him on Twitter at Mark J. Kings, and you can also reach me on at Esmeraldo99. If you enjoyed this episode as much as I did recording it, please don't forget to favorite, like, and share. You can send in comments and email to ipseriesinfo@gmail.com. In other news, the Intellectual Property Society of Nigeria will be holding its maiden virtual conference on 30th October 2020. Team is setting a standard for intellectual property management in Africa. There are two sessions on that day. The first one is on how to ensure a seamless and digital registration system for intellectual property owners and applicants. Time is 10 a.m. West African time. The speakers include Dr. Shauri Yauri, Ms. Imen Inifeti, Mr. Mike Akpan, and Mr. Oluwatobilola Moody. The second session will be on exploring alternative modes of acquiring intellectual property rights. Time is 2 p.m. Speakers, West African time. Speakers include Ms. Adua Akoma, Mr. Afam Wokedi, Mr. Mark Ikombe, and Mr. Henry Ezileoha. The link to register will be shared this week. Don't forget to register. I look forward to seeing you guys on that day. So yeah, don't forget the hashtags are hashtag NSARS, hashtag bad governance in Nigeria, hashtag police brutality, hashtag end police brutality, hashtag end police brutality in Nigeria. 20th October 2020, we will not forget. We will not forget. Nigeria bleeds. Congo as well is bleeding. We hope that things will get better in Nigeria and in other African countries where there seems to be some form of unrest.